So first, I can say that is a candid admission by everyone that his sessions are so lucidly explained that one can always understand better. And secondly, in the lighter vein, there can be no denial of the fact that his knowledge is to the highest level, which can only be appreciated, and one can be always kept in awestruck. That tone has no significance with the topic as such, but yes, it can be clearly said that his way of taking things forward is always fascinating and encouraging for every professional and a student to understand those aspects. Admissions and trials with more specific reference to the civil suits is the today's topic. But before we take things forward, I will just tell that those who are connecting for the first time, that Mr. S.R. Somasekhra has taken few sessions with us, and all his sessions have been doing well. And in fact, the #1 session on popularity is by him. So those who want to connect with the previous webinars of Mr. Somasekhra can always connect with the Beyond Law CLC platform and watch that. And secondly, all those other sessions which we have done more than 5 can also be watched and shared amongst your friends if you want. And since it's a Sunday evening, without making you more lazy, we will go with a innings just like what we saw of Dinesh Karthik day before yesterday. And the same way, there will be flurry of knowledge sharing and flurry of shots which are full of knowledge and judgments. Over to you, sir.
Thank you, sir. Good evening, friends. The subject is admissions and denials with special emphasis on civil trials. You're able to hear me? Are you able to hear me? Yes. I have proposed to divide the subject into 3 parts. I have proposed to divide the subject into 3 parts. Admissions and denials as far as pleadings are concerned. Then during the course of trial, that is evidence. And then I will take through the relevant provisions of the Commercial Codes Act at the end, where it contemplates a specific kind, a special and specific kind of denial there. 3 parts. My notes indicates that on 2/10/2021, about 8 months back, I had spoken on this platform on pleadings. For a few, it may be a repetition because on that day when I spoke about pleadings, I had referred to the provisions of Order 8 CPC, which deals with the denials. The subject is such that some repetition is unavoidable. I will do that also. Now, straight away, let me go to the provisions of Order 8 CPC, which speak of denials. I will come to that part of Order 8, which has been amended by the commercial courts at the end. We will take up CPC as it is. Kindly go to Order 8, Rule 3 CPC. Denial to be specific. It shall not be sufficient for a defendant in his written statement to deny generally the doubts alleged by the plaintiff, but the defendant must deal specifically with each allegation of fact of which he does not admit the truth except damages. Many times we say that averments in paras 1 to 6 of the plaint are false. Plaintiff is put to state proof of it. That is no denial in the eye of law, or at least having regard to the language of Rule 3 of Order 8 CPC, that cannot be said to be a specific denial. In the case of the plaintiff feels that he is a member of the joint family consisting of himself and the defendants, and the suit properties are joint family properties, it is not just sufficient to say that the averment in para so and so, or the plaint, that the suit properties are joint family properties and the plaintiff is a joint family member are false. That is not sufficient. Why it is not so? What according to you? There must be a specific denial of it. Rule 4, evasive denial. Where a defendant denies an allegation of fact in the plaint He must not do so evasively, but answer the point of substance. Thus, if it is alleged that if, in fact, it should have been an illustration, but in the main part of the section itself, portion itself, it is stated. Thus, if it is alleged that he received a certain sum of money, it shall not be sufficient to deny that he received that particular amount, but he must deny that he received that sum or any part thereof, or else set out how much he received. And if an allegation is made with diverse circumstances, it shall not be sufficient to deny it along with those circumstances. Defendant, being the owner of the suit schedule property, entered into an agreement of sale with the plaintiff and executed an agreement of sale, agreeing to sell the property for a consideration of 25 lakhs and received a sum of rupees 10 lakhs as advance, and further agreed to execute the sale deed within 6 months from the date of the agreement, by which time the plaintiff should pay the balance sale consideration. If you simply make a denial, are you denying the ownership of the defendant? Are you denying the agreement of sale? Are you denying the amount of consideration agreed? Are you denying the amount of advance amount received? These things will have to be very specifically denied. Rule 5, specific denial. Every allegation of fact in the plaint, if not denied specifically or by necessary implication, or stated to be not admitted in the pleading of the defendant, shall be taken to be admitted except as against a person under disability. That is, if the defendant is a minor or a person of unsound mind. In other cases, if there is no specific denial or a denial by necessary implication, it means that the defendant has admitted that part of the averment made in the plaint. Provided that the court may, in its discretion, require any fact so admitted to be proved otherwise than by such admission. I will have an occasion to get back to this proviso to sub-rule 1 of Rule 5 sometime later during this presentation, because there is a similar proviso attached to Section 58 of the Evidence Act, and what I tell you about Section 58 would equally apply to this. Therefore, I don't right now take up what this proviso means, when it can be applied by the court. Sub-rule 2. Where the defendant has not filed a pleading, it shall be lawful for the court to pronounce judgment on the basis of the facts contained in the plaint, except as against a person under a disability, but the court may in its discretion require any such fact to be proved. We have a similar provision under Order 8, Rule 10, and the legal position is, despite the defendant not filing his written statement, he has a right to cross-examine the plaintiff, and the court must be satisfied about the plaintiff's claim. It cannot just automatically declare the suit going by the literal language of Order 8, Rule 10. It must write a judgment. It must be convinced that the plaintiff has established the claim. That is the law of the land. In exercising discretion under the proviso to sub-rule 1 or under sub-rule 2, the court shall have due regard to the fact whether the defendant could have or has engaged a pleader. Supposing the defendant had no opportunity to engage a pleader or did not engage it, and he has just admitted every averment made in the plaint, the court will have to be extremely careful and may have to call upon the plaintiff to prove his case independent of such a consent stand taken by the defendant. Sub-rule 4 is not necessary for this session. The title then, the marginal note to each of these rules is very interesting. Rule 3, denial to be specific. Rule 4, evasive denial. Rule 5, specific denial. I really wonder as to why there should have been 3 separate rules for this. Probably the legislature also wanted to be very specific in the matter of this specific evasive denial, and therefore it chose to make 3 separate rules. Ultimately, the substance of all of them is that there must be a specific denial of an averment. Here, lawyers will have to be extremely careful. Experience has shown, I will give 2 or 3 examples that will be easy for you to understand. Many of you have already heard me on a number of occasions. You may think that I always give an example from a suit for specific performance and suit for partition. The reason is they are the suits which come before the trial courts. Of course, suits for declaration is also there, but particularly in suits for specific performance and partition, these denials and admissions, they are very important. Oftentimes we see that in the second or third paragraph of the written statement, there is a denial of the case of the plaintiff that the defendant entered into an agreement. The defendant would have also stated it is specifically denied. Then he would say that the plaintiff is put to strict proof of the same. A judge who frames issues, if it does not go through the remaining part of the written statement, or a lawyer appearing for the plaintiff does not go through the written statement carefully and fully, he would be under the impression that he is required to prove the execution of the agreement of sale by the defendant. If you go through the written statement carefully and fully, you will find that somewhere in the penultimate paragraph or a little earlier, the defendant would have admitted the agreement of sale. The plea is that the defendant was in financially strained circumstances. He approached the plaintiff, was known to be a professional money lender or otherwise a person who would lend money for interest. He insisted on a document in the nature of an agreement of sale as a security for the loan. Defendant, being hard pressed for money, executed such an agreement of sale. Neither the defendant had an intention to sell the suit property, nor the plaintiff had an intention to buy the property. This is not an agreement. The transaction is not an agreement of sale, though the document reads like an agreement of sale. Is it a case where the plaintiff is required to prove the execution of the document? Defendant takes the burden of proving that the document came into being in the circumstances pleaded by him in the written statement. In fact, a question often would arise whether such a plea is barred by the provisions of Section 92 of the Evidence Act. I know I am slightly deviating, but it is worth deviating. As most of you may be now knowing, under Section 91 of the Evidence Act, if a transaction requires to be in writing, or the parties choose to put the transaction in writing, then writing alone is the evidence, no oral evidence can be given. And that writing has to be proved. Then once that writing is proved in a manner provided by Section 91, 92 prohibits the parties from letting in oral evidence to contradict the terms of that document, to vary the document, to modify the document, and other things. The Honorable Supreme Court in a good number of decisions has held that if the case of the party is that though the document is styled as a sale deed or whatever it is, the intended transaction is altogether different, 92 would not be a part. There are a number of decisions of the Supreme Court. The out-cited one is reported in AR 1982 SC 20. AR 1982 SC 20. This is not an occasion to go deep into the provisions of 91 and 92. It's only for your information. If the defendant takes up such a plea, that plea is not barred by the provisions of Section 92 of the Evidence Act. Why I am telling you this is not a case of specific denial of the execution of the agreement of sale. Read the written statement carefully, then counsel appearing for the plaintiff should decide as to what he is required to prove. Here, there is something more to tell. The plaintiff issues a legal notice to the defendant or defendants, proposing a partition or claiming a share in the partition, asking them to come forward to effect a partition, failing which he would initiate legal action. Or he may say that he is the owner of the property by some means, his title is denied, possession is interfered with, then in reply to that notice, in reply to that notice, the defendant sets up a will executed by a person who may be related to the plaintiff or not related to the plaintiff. What happens is, in the plaintiff would have mentioned the defendant in his reply has referred to a will which is concocted, forged. The testator was not in a sound disposing state of mind at all to execute such a will. Here the problem lies. Many think that it is an admission on the part of the plaintiff about the will. The legal position is very clear. He who propounds the will have to establish it. This cannot be taken as an admission on the part of the plaintiff about the execution of the will, and even otherwise, in view of the proviso to section 68 of the Evidence Act, despite such admission, the defendant who propounds the will have to prove it by examining at least one attesting witness. In fact, I have told the judicial officers also in the Judicial Academy that no issue need be framed, casting the burden on the plaintiff to prove that the will is forged, concocted, testator was not in a sound disposing state of mind. That is a burden which has to be placed, that cannot be placed on the plaintiff. It is for the defendant to do this. Therefore, what is admitted and denied extremely is a very important thing which a lawyer should keep in mind. Here again, a slight deviation, not totally irrelevant to the subject. I refer to section 68 of the Evidence Act, which requires the propounder of a will to examine at least one attesting witness to prove the execution of the will. The section 68 is not confined to wills. It says any document which requires attestation, if its execution is denied, it can be proved by examining at least one attesting witness. Maybe when I spoke on this platform about suits for declaration of title and other connected aspects, I have given this example. It's worth repeating. Let us take a case where the plaintiff claims title on the basis of a gift deed executed by one X who is not a party to the suit. The defendant denies the execution of the gift deed. That X enters the witness box and supports the plaintiff, saying that he or she has executed the gift deed in favor of the plaintiff. Section 68 proviso says execution of such a document, if specifically denied by the person purporting to have executed, then only requires the other side to examine the attesting witness. This is not a case where the executant has denied the execution of the document, the defendant has denied it, examination of the attesting witness would not be necessary. All right, we will reserve it for some other occasion. Let us get back to this. Now, practitioners should know one thing. There has been a practice in some places. After the written statement is filed, the plaintiff files what is known as a reply statement, rejoinder, replication, by whatever name you call it. Order 8 Rule 9 provides for it. It is not mandatory to file it. Even if the defendant pleads certain facts, takes up a specific stand, plaintiff is not required to meet them or deny them by filing a reply statement or replication or rejoinder. There is no need. It cannot be contended that the plaintiff, in answer to the written statement, has not filed a reply statement. Take another case where the plaintiff files a suit for partition, defendant sets up a will. Plaintiff does not file a reply statement. It cannot be said that the plaintiff has admitted the case of the defendant insofar as will is concerned. Or the defendants plead that certain properties of their self-acquisitions. Plaintiff does not file a reply statement. It cannot be said that the plaintiff has admitted that the properties referred to in the written statement are the self-acquisitions of the defendant. Long back, we had a decision of the Karnataka High Court, but now the Supreme Court has said so. In 2009, 1 SCC 354. 2009, 1 SCC 354. A. Lakshmanan versus Tetrail Padmini. THEKKAYEL. A. Lakshmanan versus Tetrail Padmini. Non-filing of the replication does not mean that there is an admission of the facts pleaded in the written statement. Yet another thing which the advocates appearing for the defendants while drafting the written statement should bear in mind is either you should admit it or deny it, or which sentence of the plaintiff you are going to admit, which you are going to deny. There must be a specific denial of it. Supposing you say that the averment in a particular para of the plaintiff is not within your knowledge, despite saying that the plaintiff is put to strict proof of the same, Supreme Court has held that it does not amount even to an implied denial. Let me repeat, a plea in the written statement that the defendant is not aware of a particular averment made in the plaintiff does not amount even to an implied denial. We have an earlier decision of the Supreme Court which has been subsequently followed. The earlier decision is AER 1967 Supreme Court 109. AER 1967 Supreme Court 109. Jafurisa, JAFAURISAH. JAFAURI, Jafurisa versus Dwarika Prasad. Dwarika Prasad. This decision has been subsequently followed in Muddasani Venkata Narsayya. Muddasani Venkata Narsayya versus Muddasani Sarojana. 2016, 12 SCC 288. 2016, 12 SCC 288. I may tell you incidentally that many times we learn from the opponent counsel also. Ultimately, we may win the matter, but there are certain things which we learn from the opponent counsel. As a junior lawyer practicing in my native place, I filed an election petition challenging the election of the president for APMC, Agricultural Produce Marketing Cooperative. I think maybe I appeared for the respondent or something of that kind. I had simply said that these facts are not within the knowledge of the respondent. A senior lawyer said there is no denial at all. I said that I have denied. He said a plea of want of knowledge does not amount to denial at all. Of course, subsequently, I also investigated this. So many times we learn from the opponent counsel also. Then we have this another plea. It happens in suits for money. Defendant denies the transaction, execution of the pro-note, loan agreement, hypothecation agreement, or whatever it is. Then says, without prejudice to what is stated above, that is not the interest agreed to be paid by the defendant. Plaintiff took his signature to some bank documents without prejudice. And then he says, defendant is in strained circumstances, some installments to be granted. What is this without prejudice? Very recently, the Karnataka High Court had an occasion to examine this. We have a very beautiful judgment of a very learned judge of the Karnataka High Court. In 2021, SCC Online, Karnataka 12184. I repeat, 2021 SCC online, Karnataka 12184, RFA regular first appeal number RFA 2047 of 2010, dated 6/5/2021. Dated 6/5/2021. This judgment in turn makes a reference to number of judgments of the English courts, and one of the Supreme Court reported in 2018 5 SCC 99. 2018 5 SCC 99. I will give the party's name as per the Supreme Court decision is concerned. ITC Limited versus Blue Coast Hotels Limited. ITC Limited versus Blue Coast Hotels Limited. The decision of the Karnataka High Court, as I said, is in the decision that is a suit for recovery of money. The trial court had dismissed the suit. Plaintiff filed the first appeal before the High Court. Then, with regard to denial, also the learned judge has referred to number of judgments of the Supreme Court, saying when it amounts to denial and all that, absence of pleadings, variance between pleading and proof. Then, this is how the learned judge begins. I am tempted to read some 2 or 3 paras in the judgment that would give you a better insight into this, because the court has specifically considered this question. Next question that requires to be considered is the effect of para 10 of the written statement, which is hedged by without prejudice, and therefore can the defendant wriggle out of certain statements made regarding mode of payment to the plaintiff claimed by him. He pleads discharge, then he says without prejudice. Authorities of the subject clearly say no. He is bound by the said statement. Then see how beautifully it is put. Without prejudice rule offers him no asylum. Without prejudice rule offers him, that pronoun him refers to the defendant, offers him no asylum. Without prejudice rule is a role of hoary lineage. Eminent law lords have pronounced on this vexed rule, often with a tone of exasperation. I checked the dictionary. The meaning of the word exasperation is anger and annoyance. But if there was unanimity on any one aspect among them, it is this, that the rule is based on sound public policy, and the salutary object underlying this rule is to encourage and facilitate parties to seek negotiated settlement of disputes without recourse to court, and unless some protection is given to the parties for stating their mutual position, they will be inhibited from placing their cards on the table, lest what they have disclosed during negotiation might be used against them as evidence. That is why in the mediation rules it is specifically stated, if something is disclosed during the mediation proceedings, that cannot be taken as a ground in the court. No, there is that admission during mediation proceedings. The guiding principle is that parties should be encouraged so far as possible to resolve their dispute without resort to litigation. It can therefore be taken as fairly well settled that without prejudice rule is a part of public policy, and the same is sanctified almost to a rule of law to encourage negotiated settlements of legal disputes, and therefore, please mark these words, and therefore its applicability is limited to the stage before the parties knock at the doors of the court. What is it that we are doing? After the parties knock the doors of the court, we say without prejudice. Even during the negotiation stage before the litigation commences, the judicial opinions have been divergent on the extent of applicability of this rule. English authorities refer. Then it may be added that the decision of the House of Lords in Bradford and Bingley case has been approvingly quoted by the Honorable Supreme Court. That is the one. ITC Limited versus Blue Coast Hotels Limited, 2018 5 SCC 99. The learned judge of our High Court extracts the judgment of the Supreme Court, worth reading. Much was sought to, this is the view of the Supreme Court. Much was sought to be made by the words without prejudice in the letter containing the undertaking that if the debt was not paid, the creditor would take over the secured assets. The submission on behalf of the debtor that the letter of undertaking was given in the course of negotiations and cannot be held to be any evidence of the acknowledgement of liability of the debtor, apart from being untenable in law, reiterates the attempt to evade liability and must be rejected. The submission that the letter was written without prejudice to the legal rights and remedies available under any law, and therefore the acknowledgement of the undertaking has no legal effect, must likewise be rejected. This letter is reminiscent of a letter that fell for consideration in Spencer's case, as pointed out by Mr. Harish Salvage and other things are there. Therefore, you will have to be very careful in taking a plea that without prejudice to what is stated above, the defendant wants time. Particularly, this happens in money suits, partition suits, and other suits also. This happens. You will have to be extremely careful in that regard. Now, this is with regard to the provisions of Order 8, Rules 3 to 5 CPC, and the case law on the point. Now, we shall go to the provisions of the Evidence Act and refer to admissions and denials, more particularly admissions. Now, suffice to say, as far as the first part of this presentation is concerned, that the denial must be very specific. It cannot be evasive. It should be strictly in terms of Order 8, Rule 3.5. Don't take the risk of saying without prejudice. Some of you have heard me. I find a few judicial officers also have logged in. They have heard me in the Judicial Academy. I always say about this judicial and evidentiary admissions. Judicial and evidentiary admissions. What is this judicial admission and evidentiary admission? Let us go to section 58 of the Evidence Act. For the benefit of the uninitiated, I may tell you that the Evidence Act refers to admissions at two places. One in the first part relating to relevancy of facts, commencing from section 17, ending with 31, and in the second part, proof of facts under section 58. I'll first take up section 58. No facts admitted need not be proved. No fact need be proved in any proceeding which the parties thereto or their agents agree to admit at the hearing. We have not reached a stage in this country, at least, where the parties agree to admit something at the hearing, very unlikely, or which before the hearing they agree to admit by any writing under their hands. This Sarkar in his Evidence Act, I will read, that says, this refers to a situation where interrogatories are delivered under Order 11, or when notice to admit facts is given under Order 12. First, agree to admit at the hearing. Such a situation is not a possibility in the remote future, which before the hearing they agree to admit by any writing under their hands, or which by any rule of pleading in force at the time they are deemed to have admitted thereby pleadings. I have read Order 8, Rule 3 to 5. It speaks of specific denials. Denial need not be evasive and all that, and have specifically stated that denial should be very specific. Therefore, if the denial is not specific, by a rule of pleading, Order 8, Rule 5 says it is deemed to have been admitted. These are the admissions referred to in section 58, They are called judicial admissions. That is, admissions made after the matter enters the portals of the court and the court records. They need not be proved. They need not be proved. Please make it clear. What need not be proved? Judicial admissions referred to in section 58 of the Evidence Act need not be proved. I will just read out to you a passage from Sarkar's Law of Evidence and then dilate on this. In the 16th edition of Sarkar's Law of Evidence, Volume 1, 16th edition, Volume 1, at page 1140 and 1141. 1140 and 1141. Dealing with the principle and scope of section 58, this is what the learned author says. Admissions by parties, oral or documentary, to any person before the suit, out of court, have been dealt with section 17, etc. Admissions by parties, either oral or documentary, before the suit, that is before the filing of the suit, have been dealt with in section 17. I will tell you when that 17 would apply. Such admissions are tendered as evidence, while admissions for purposes of trial dispense with proof of particular facts. This section, that is 58, deals with admissions during trial, that is at or before the hearing. Proof of such facts is dispensed with for the simple reason that the facts admitted require no proof. They are known as judicial admissions or stipulations dispensing with proof. Then, admissions in pleadings are judicial admissions admissible under section 58 made by the parties or their agents at or before the hearing of the case stand on a higher footing than evidentiary admissions. The former class of admissions are fully binding on the parties that make them and constitute a waiver of proof. The defendant in the written statement clearly admits the agreement of sale referred to by the plaintiff, but says that time was of the essence of the contract. Plaintiff was never ready and willing to perform as part of the contract. Hardship would be caused to him if a decree for specific performance is passed. Contract has become frustrated. Here is a case where there is a clear admission of the execution of the agreement of sale. The former class of admissions, that is judicial admissions, are fully binding on the parties that made them and constitute a waiver of proof. No issue need be framed about the execution of the agreement of sale, and with regard to time being of the essence of the contract, as the law stands in the case of immobile property, the time is not of the essence of the contract, is the presumption. Therefore, the defendant has to establish it. Then, they by themselves, that is judicial admissions, can be made the foundation of the rights of the parties. On the other hand, evidentiary admissions which are receivable at the trial as evidence are by themselves not conclusive. They can be shown to be wrong. Then admissions for the purpose of trial, that is judicial admissions, may be considered as being made on the record, which are actual either in the pleadings, that is Order 8, Rule 5, or in answer to interrogatories, Order 11, Rule 22, implied from the pleadings, Order 8, Rule 3, 4, 5, between the parties by agreement in writing before the hearing, by notice under Order 12, Rules 1 to 4, at the hearing by party or his lawyer. This is the legal position with regard to these admissions. Now, I will dilate on the 17 and 58 a little later. Before that, kindly make a note of some old decisions of the Supreme Court. I have a reason to cite these old decisions because the law is very beautifully laid down in them. The language of section 58 of the Evidence Act 31 of the Evidence Act has been extracted, that has been explained, and we have got number of earlier decisions of the Supreme Court explaining the concept of these admissions. To understand that, you need to make a reference to section 31 of the Evidence Act. Admissions are not conclusive proof of the facts admitted, but they may operate as estoppels under the provisions hereinafter contained. That is what section 31 says. Admissions are not conclusive proof of the matters admitted, but they may operate as estoppels under the provisions hereinafter contained. This is very, very important. I will give a few illustrations. Before that, let me refer to these decisions of the Supreme Court, which explain the scope of these provisions. One important decision of the Supreme Court, to which I find a profuse reference in Sarkar's Law of Evidence and elsewhere also, is in this famous Nadubai Ammal versus B. Shamrao. Nadubai Ammal versus B. Shamrao, reported in AER 1956 SC 593. AER 1956 SC 593. This is what the Supreme Court has to say about admissions. An admission is not conclusive as to the truth of the matter stated therein. It is only a piece of evidence. That is why you find section 17 to 31 in the first part of the Evidence Act dealing with relevancy. Section 5 of the Evidence Act says facts which are declared as relevant by the Evidence Act and nothing else can be received by the court. There is a mandate to the court. There is a mandate to the court. There is an injunction against the court. Don't receive anything. Unless I say that it is relevant, don't. The Evidence Act says, I have declared certain facts to be relevant. Don't receive anything beyond what I have stated. You will find section 17 to 31 in that part of the Evidence Act dealing with relevancy of facts. It is only a piece of evidence. The weight to be attached to which must depend on the circumstances under which it is made. It can be shown to be erroneous or untrue. It can be shown to be erroneous or untrue, so long as the person to whom it was made has not acted upon it to his detriment, when it might become conclusive by way of estoppel. That is why 31 says it may operate as estoppel, but it is not conclusive proof of this. This is a very important decision. I request the participants to read this decision, not just to know the concept of admission. It also deals with the lis pendens covered by section 52 of the Transfer of Property Act, and whether in an execution sale it could be a question of lis pendens could be raised, all that. The next decision of the Supreme Court is again a very famous decision, oft cited, AER 1960 Supreme Court 100. AER 1960 Supreme Court 400. The names of the parties are too long, but I will only give the first names. Narayan versus Gopal. Narayan versus Gopal. An admission is the best evidence that an opposing party can rely upon, and though not conclusive, is decisive of the matter unless successfully withdrawn or proved erroneous. I will tell what is the successful withdrawal and erroneous. I am giving these decisions in a chronological order: 56, then 60, now 66. AER 1966 SC 405. AER 1966 SC 405. Bharat Singh versus Bhagirathi. Bharat Singh versus Bhagirathi. Admissions have to be clear if they are to be used against the person making them. Admissions are substantive evidence by themselves. In view of section 70, substantive evidence, not conclusive evidence. Let there be no mistake about that. They are substantive evidence by themselves in view of section 17 and 21 of the Indian Evidence Act, though they are not conclusive proof of the matters admitted. We are of the opinion that the admissions duly proved are admissible evidence, irrespective of whether the party making them appeared in the witness box or not, and whether that party, when appearing as witness, was confronted with those statements in case it made a statement contrary to those admissions. The purpose of contradicting the witness under section 145 of the Evidence Act is very much different from the purpose of proving the admission. Admission is substantive evidence of the fact admitted, while a previous statement used to contradict a witness does not become substantive evidence and merely serves the purpose of throwing doubt on the veracity of the witness. What weight is to be attached to an admission made by a party is a matter different from its use as admissible evidence. This is very simple. A piece of evidence may be relevant, declared relevant by the provisions of the Evidence Act. It is relevant, it may be admissible. Out of what use? What weight can be attached to it? It is a matter for appreciation of evidence. I will come to 145 of the Evidence Act also in about 5 minutes. Then AER 1967 Supreme Court 341. AER 1967 Supreme Court 341. Basant Singh versus Janki Singh. Basant Singh versus Janki Singh. An admission by a party in a plaint signed and verified by him in a prior suit, is an admission within the meaning of section 17 of the Indian Evidence Act and may be proved against him in another litigations. Section 17 of the Indian Evidence Act makes no distinction between an admission made by a party in a pleading and other admissions. Under the Indian law, an admission made by a party in a plaint signed and verified by him may be used as evidence against him in other suits. In other suits, this admission cannot be regarded as conclusive and it is open to the party to show that it is not true. Then, AER 1974 SC 117, AER 1974 SC 117, Vishwanath Prasad versus Dwarka Prasad. Vishwanath Prasad versus Dwarka Prasad. Some contention was urged that certain statements which were marked in evidence had not been put to the plaintiff when he was in the witness box. There is reference to the exhibits in para 8 that I need not read. The contention was that they had not been put to the first plaintiff when he was in the witness box or to the 8th defendant. Although he had discreetly kept away from giving evidence, they cannot be used against him. Counsel drew our attention to section 145 of the Evidence Act. There is a cardinal distinction between a party who is the author of a prior statement and a witness who is examined and is sought to be discredited by use of his prior statement. In the former case, an admission by a party is substantive evidence if it fulfills the requirements of 21 of the Evidence Act. In the latter case, a prior statement is used to discredit the credibility of the witness and does not become substantive evidence. In the former, there is no necessary requirement of the statement containing the admission having to be put to the party because it is evidence proprio vigore. In the latter case, the court cannot be invited to disbelieve a witness on the strength of a prior contradictory statement unless it has been put to him, as required by section 145 of the Evidence Act. This distinction has been explained in Bharat Singh's case. Then, AER 1974 SC 471. AER 1974 SC 471. Nagin Das versus Dalpat Ram. Nagin Das versus Dalpat Ram. Admissions, if true and clear, are by far the best proof of the facts admitted. Admissions in pleadings or judicial admissions admissible under section 58 of the Evidence Act made by the parties or their agents at or before the hearing of the case stand on a higher footing than evidentiary admissions. The former class of admissions are fully binding on the party that makes them and constitute a waiver of proof. They by themselves cannot be made the foundational rights of the parties. On the other hand, evidentiary admissions which are receivable at the trial as evidence are by themselves not conclusive. They can be shown to be wrong. AER 1977 SC 1724. AER 1977 SC 1724. It is in relation in election matter, but the law is laid out. Thiru John, THIRU, Thiru John versus the returning officer. It is well settled that a party's admission as defined in 17 to 20, fulfilling the requirements of 21, is substantive evidence pro priori vigore. An admission, if clearly and unequivocally made, is the best evidence against the party making it, and though not conclusive, shifts the onus on to the maker on the principle that what a party himself admits to be true may reasonably be presumed to be true until the presumption is rebutted. The fact admitted must be taken to be established. Now, a reading of some of these decisions gives an indication that there is some conflict between them. What is this admission referred to in section 58 and what is it that is referred to in section 70? This conflict has been resolved, rather explained, saying that there is no conflict at all. Both the decisions are reconcilable. That is in Dilip Kumar versus Ramu. Dilip Kumar versus Ramu. It's a Karnataka judgment, ILR 1992 Karnataka 2905. We need not go to that judgment, but I will tell you what it is. I just want to make it clear that I am not making an academic presentation of these things. I don't believe in it. You are all professionals. You should know how to make use of these provisions in conducting a civil trial. My concern is that I do not know what the trend elsewhere in the country is. Here in Karnataka, I have worked in a few places and again after retirement doing arbitration. This is what I have found. Plaintiff is in the witness box. A question is asked to him by the opponent counsel. Have you stated so in the plaint? Have you not stated so in the plaint? Defendant is in the witness box. A similar question is put by the plaintiff's counsel. Have you stated so in the written statement or have you not stated so in the written statement? Plaint and written statement are not previous statements to be confronted. There is no question of contradicting the plaint or the written statement under 145 of the Evidence Act. They are a part of the record. Admissions contained in the plaint and the written statement are judicial admissions which need not be proved. That is what section 58 of the Evidence Act says. But a different situation arises. The suit which is being tried is between X and Y. X is the plaintiff in this suit. Y is the defendant in this suit. There is another suit between X and Y where their rank is interchanged. Y is the plaintiff in that suit. X is the defendant in that suit. Either X or Y in the other suit would have taken a stand contrary to the stand taken in the present suit, that is, which is under trial, or inconsistent with it. Then The plaintiff's written statement in the other suit needs to be confronted to him. An opportunity has to be given. It is open to the plaintiff or the defendant when confronted with the written statement or the plaint in the previous suit to give an explanation. Whether the court ultimately accepts the explanation or not is a different matter. It is in the realm of appreciation of evidence. Law permits him to explain it. That is what says, unless the admission is successfully withdrawn or erroneous. Under an erroneous impression, I did it. Now let us take a case where a suit is for permanent injunction. Plaintiff says at a partition, the suit property fell to his share. Since then, he is in exclusive possession. The defendants, who are his brothers or someone, are interfering with his possession. This is the stand taken by the plaintiff in a particular suit. Now, in some other suit, he takes a stand that the properties are yet undivided. Maybe the defendant in the suit files a suit for declaration and a similar argument that there is a partition and he is the owner of it or something of that kind. He takes a different stand, saying that there is no partition and there cannot be an injunction against him. It is in a different suit. Now, the plaintiff in the previous suit who had filed it one for injunction is the witness box in the other suit. The plaintiff in the previous suit can be confronted to him. Have you filed such a suit or did you file such a suit? He may deny or admit. Then confront the plaintiff to him. Did you plead in that suit that there is already a partition and the property which was the subject matter of the suit, which may incidentally be one of the properties in the suit for partition, declaration, whatever it is, there is already a partition and you are in exclusive possession. He may admit it. He may also say, well, I wanted loan from a bank. The bank was not prepared to lend money without there being a document evidencing partition. It was in those circumstances we prepared some palupatti or whatever it is, that the Tata chain and other things. It was in those circumstances there is actually really no partition. The court may not ultimately accept that explanation. Other evidence may prove it to be wrong. But an opportunity is available. Law gives that opportunity to the party to explain why he made that admission. There could be a sale deed. Well, in a suit for partition, the father may contend that it is joint family property only, or one of the defendants the plaintiff may contend that it is joint family property only, but the sale deed was taken in the name of one of the sons for some purpose to avoid payment of heavy income tax, all that. Whether those pleas are hit by the provisions of the Benami Transactions Act is a different aspect of the matter. Such a plea is taken. Now it is in the previous suit, such a stand was taken. It may be open to him to explain, well, for this reason we took up such a stand. Therefore, the plaintiff in the previous suit or in some other connected suit or the written statement in that suit can be confronted, should be confronted, and an explanation will have to be taken. But the plaintiff written statement in the very suit in which evidence is going on need not be confronted, should not be confronted, cannot be confronted. Please be brief. It is a judicial admission. I go a step further. In a suit for partition, the defendants take up a plea that certain items of the suit schedule are joint family properties. They admit that they are joint family properties, set up a prior partition as far as those items are concerned. In respect of the rest, they take a stand that they are their self-acquisitions. Please be very clear about this. Let me restate the facts. Suit is for partition. Defendants take up a contention that items so and so are joint family properties, but there has already been a partition. Rest of the properties are our self-acquisitions. That is the stand taken by the defendants. One of them is in the witness box. I have seen this in my experience as a trial judge. despite there being a clear admission in the written statement, a judicial admission that the other that some items so and so are joint family properties, the counsel for the plaintiff still puts a question that items 1, 2, 3 are joint family properties. There is already an admission. And forgetting that there is an admission, or intentionally or ignorantly, inadvertently, by whatever it is, the defendant who is the witness party delays it. Are you following what I am telling? There is a clear admission in the written statement that those properties are joint family properties. Despite that admission, the plaintiff counsel makes a suggestion to him that they are joint family properties. This defendant, somehow the defendants parties have a tendency to deny everything that is put to them in the witness box. Just as an accused denies everything when examined under 313 CRPC, he simply says no. Now, during the course of arguments, a contention is urged. No, in the evidence he has stated so. Are we to go by the judicial admissions contained in the written statement, or by this suggestion, a suggestion which would not have been made and an answer which should not have been given? Therefore, please stop here afterwards from tomorrow the habit of confronting the plaintiff and the written statement in the suit in which the trial is going on, putting suggestions in line with it or contrary to it. Sometimes I have also seen a different stand is taken during the course of trial, forgetting what the stand taken in the plaintiff or written statement is. Please avoid that. So, plaintiff or written statement in a previous suit needs to be confronted. An opportunity has to be given to the appellant to explain. As I said repeatedly, explanation may not be acceptable. It may be self-serving. Only to get over that he may give it. But if the court is convinced that is an explanation worth accepting, that could be done. Then we have what is known as, during the course of trial also, denials to be very specific, not just in the pleadings. Denials to be very specific during the course of trial also. You must specifically deny. If you have taken a stand that the agreement of sale is not executed by the defendant at all, put him. This is not the signature of the defendant. He did not execute this document. The signature is for. Make a specific denial. Suddenly taking a stand, you took his signature on a blank paper. A suggestion contrary to the stand taken in the written statement. Please avoid this. I am not accusing anybody. My experience tells this is the way the trial goes on. Maybe there is lack of preparation. Maybe the plaintiff and the written statement are not looked into, or maybe they take a chance during the course of trial. Any stand taken by you without a foundation in the pleading will not take you any further. And then there must be consistency and uniformity in making the suggestions, whether to the same witness or different witness. To one witness, a suggestion is made. To another witness, a different suggestion is made. In the written statement, a stand is taken. In the plaintiff, a stand is taken. Some other suggestion is made. Consistency in suggestions, uniformity in suggestions is required. Though I said that the emphasis is on civil trial, in proceedings under 138 of the NI Act, this is what I have noticed. The first occasion for the accused to state his case is when he receives the notice of dishonor. If he replies some stand. The second occasion is when the complainant is in the witness box while cross-examining. A suggestion which is not found in the reply statement is put to the complainant in the witness box. Third, when the accuser gets an opportunity to have his say when examined under 330, many times no stand is taken, a simple everything is denied. Fourth, when the accused enters the witness box, different stands are taken. They would not take you anywhere, particularly when there is a presumption under 139 of the Evidence Act. Therefore, Let there be consistency and uniformity in making suggestions or denials, whether to the same witness or different witnesses. I told you that I would take you through the provisions of Section 145 of the Evidence Act. You will find that 145 is in Part 3 of the Evidence Act dealing with production and effect of evidence. 17 and 21 are in first part dealing with relevancy. 58 is in the second part dealing with proof of facts. 145. You see where it is placed. It is in chapter 9 with the title Examination of Witnesses. 135 Order of Production and Examination of Witnesses. 136 Judge to decide as to admissibility of evidence. 137 Examination in Chief cross re-examination. 138 Order of Examination. 139 cross-examination of a person called to produce a document. 140 Witness to character. 141 Leading question when can be asked. 142 when cannot be asked. 143 when they may be asked. 144 evidence as to matters in writing. From 145, you see a host of provisions dealing with what is permissible in cross-examination. Cross-examination as to previous statements in writing 145. Questions lawful in cross-examination 146. 147 when the witness may be compelled to answer. 149 questions not to be asked without reasonable grounds. 151 indecent and scandalous questions to be avoided. 152 questions intended to insult or annoy could be avoided. The title of this part itself is Production and Effect of Evidence. I read out some 2 or 3 judgments of the Supreme Court which say that the purpose of confronting a document under Section 145 is to test the credibility of the witness. They are different from a previous statement made under Section 17, which is an admission by itself. Let me read 145. A witness may be cross-examined as to previous statements made by him in writing or reduced into writing and relevant to matters in question without such writing being shown to him or being proved. Those of you who have been practicing on the criminal side are making use of Section 145. 145, take it from me, it is not confined to a criminal trial. Even in a civil trial, 145 can be effectively made use of. How it is made use of in a criminal trial? The witness is confronted, is asked a question. Did you state before the police? If he says he did not state, the matter ends there. If he says he stated something, then the next question is, did you state in these terms? Supposing he says, I have stated, then also the matter ends, without the writing being shown to him. But if it is intended to contradict him by his writing, his attention must, before the writing can be proved, be called to those parts of it which are to be used for the purpose of contradicting him. This is what you are doing in a criminal trial. He is asked a question whether he made such a statement before the police. If he says yes, end of the matter. If he denies, then that portion is confronted to him. It then gets marked. In a civil case, in the chief examination, a document gets marked. In a criminal case, under statements under 161, they get marked during the course of cross-examination on behalf of the defense or when the prosecution treats him hostile. Now come back to a civil case. Let us take a simple suit for recovery of money. Now, before the suit is filed, the defendant has sent a letter to the plaintiff or SMS or a WhatsApp message saying that he is in some strained circumstances. He needs about 2 months' time to make payment. He does not give any more details. He doesn't say that he borrowed money from the plaintiff on a particular date. He executed some document, nothing. He simply says, well, The amount which I am due to you, I will pay after another 3 months because I am now hard pressed for money. The letter is with the plaintiff, or he has saved that message. The defendant in the written statement denies the loan. Defendant is in the witness box. Previous statement does not mean a statement recorded before a magistrate or before a tahsildar or before a police. It is a statement in writing, right? Now the defendant can be asked when he is in the witness box, you are able to write, you can identify your writing and all that. Is it a letter written by you? Or before that, did you write a letter to the plaintiff seeking time to make payment? If he says, I wrote it, that is the end of the matter. That is without that writing being shown to him. That is the first part of 145. Second part says, but if it is intended to contradict him by the writing, no, I did not say that I need time. The thing was due from me. Why should I say so? Then his attention must be drawn. This is what you have said. This is the message that you have sent that can be confronted. I'll give one more example. Suit is for partition of certain properties. Plaintiff is, the defendants have taken a stand that there is already a partition. Well, if it is a registered partition deed, it's an easy walkover for the defendants. If it is an oral partition or a memorandum of partition, not of a previous partition or all that, there's a heavy burden on the defendants to prove that partition. That's a different aspect of the matter. Now, at one point of time, subsequent to the partition pleaded by the defendants may say about 10 years back after our father died, we effected a partition, or after our grandfather died, my father and uncles effected a partition. That would be the plea. Sometime thereafter, let us say the plaintiff has executed a sale deed in favor of a person not a party to the suit. Not a party to the suit. We'll call him X. In that sale deed, he says that the property which he is selling under the deed came to him, rather fell to him, fell to his share at a partition between him and the family members. Are you following what I am telling? Suit is for partition. Defendants take up a contention that there is already a partition. Subsequent to the alleged partition, plaintiff has executed a sale deed in favor of one X. The recitals in the sale deed say, at a partition in the family, the property which is the subject matter of sale deed fell to his share. Now, when the plaintiff is in the witness box, this certificate, because the original cannot be with the defendant, the original is with the X who has purchased the property from X. Defendant can confront a certified copy of it or a photostat copy of it or whatever it is, whatever is available with him. He may ask, do you know X? If the plaintiff is intelligent, he knows why he is asking that question. Once he says that there are several X in my place, which X? X son of Y. This is how it goes on with cross-examination. Ultimately, he gives an indication that he knows X, to which the reference is made by the defendant. Did you sell any property to him? I have sold several properties. How do I remember? If you show me the deed, I can tell something of that kind. Or he may deny it. No, I have not sold any property. Then he may say, yes, I have sold that property. Then the next question is, did you in that sale deed say that there's already a partition and that property fell to your share? If he says yes, that is the end of the matter. If he denies it, then this copy which is with the defendant can be confronted to him to show this is what he has stated. This is the purpose of 145, how we can make use of it in a civil case. Then we have these stray admissions. The legal position is very clear. These stray admissions are liable to be ignored. Here, whether it is the plaintiff, more particularly in the context of the defendant's case, There is a consistent denial of the case of the plaintiff, rather the material case of the plaintiff, in several paras of the written statement. On the same lines, a suggestion is made to the plaintiff. The defendant, in his chief examination, also denies it, takes a similar stand. During the course of cross-examination, some question is put to him. Let us say a suit for injunction. The case of the plaintiff is that there is a fence around his property. The defendant tried to remove that fence and thereby interfere with his possession. In the course of cross-examination, the defendant says, yes, I removed that fence. Yes, it is true, I removed the fence. Does it mean that the defendant has admitted the plaintiff's possession? There is a consistent denial of the case of the plaintiff. In the written statement, it is denied. In the cross-examination of the plaintiff, it is suggested that he is neither in possession, nothing, no interference. Here, it's a case of re-examination. The fence that he means is something which he has put and which the plaintiff wanted to remove. Something of that kind. It was my fence. He has put it. He had put the fence in my side of the property. Therefore, I removed something of that kind. These are all stray admissions. Secondly, unless we enter the witness box, we will not be knowing the stress that a witness undergoes in the witness box. When several questions are put to him, his mind goes blank. Even in respect of certain questions to which he knows the answers very correctly, he may draw a blank and either plead he doesn't know it, or he may keep mum, or being exhausted, he may say yes. Do not take them as admissions. In what context they are made? What is the suggestion that is made? What is the next suggestion and the previous suggestion? Don't rely upon these stray admissions. Draw the attention of the court only to those admissions and that familiar saying admitted facts need not be proved. This will not take your case any further. Examine whether they are stray admissions. They are liable to be ignored. So, to say when they are not stray admissions, the suggestion should be very clear. Many times, what I have done as a trial judge and still doing as an arbitrator is, when I entertain a doubt whether the witness has understood the question, I put the question again and I make a note also in the deposition. So a question by the court also or by the arbitrator also, the witness says so. I would ensure myself that the witness has understood the question. Because in respect of crucial aspects of the case, if he makes an admission, well, you will have to be extremely careful. Therefore, to say that an admission is not a stray admission, the suggestion should be very clear. In what context it is made should be known. Before I take up the provisions of the Commercial Courts Act, a quick look at the remaining provisions of the Evidence Act dealing with admissions. 17. An admission is a statement, oral or documentary, or contained in electronic form, which suggests any inference as to any fact in issue or relevant fact, and which is made by any of the persons and under the circumstances herein before mentioned. It just defines what an admission is. 18. Statements made by a party to the proceeding or by an agent to any such party, whom the court regards under the circumstances of the case as expressly or impliedly authorized by him to make them are admissions. Then 19. Statements by persons whose position or liability it is necessary to prove as against any party to the suit are admissions, if such statements would be relevant as against such persons in relation to such position or liability in a suit brought by or against them. The illustration given is really illustrative. I will read it. A undertakes to collect rent for B. A undertakes to collect rent for B. B sues A for not collecting rent due from C to B. A denies that rent was due from C to B. A statement by C that he owed B rent is an admission and is a relevant fact as against A if A denies that C did owe rent to B. Then 21 is important. admissions to be relevant should not be in our own favor. I can't go on telling that the property is my property. So admission, if I make an admission detrimental to my interest, then only it is an admission relevant under section 21 of the Evidence Act. Well, these are all elaborations of the main principle contained in section 21. At the cost of repetition, I am telling, admissions referred to in section 17 to 21 are called evidentiary admissions. They will have to be proved during the course of trial. They are not conclusive. They can be shown to be wrong. Whereas judicial admissions are a part of the record, either in answer to interrogatories given under Order 11, or in answer to notice to admit facts given under Order 12, or by implication, they are deemed to have admitted in the pleadings. Now, this presentation will be incomplete if I do not draw your attention to two provisions of the Commercial Courts Act dealing with denials. Most of you may be knowing that the Commercial Courts Act is in two parts. First part is part means I am not saying part one, part two that way. I am loosely using that expression. They are in two parts or in two portions. One dealing with Commercial Courts Act as such. The second is a schedule appended to the Commercial Courts Act, which contains certain amendments brought to the Code of Civil Procedure in relation to commercial courts. Certain provisions of the Code of Civil Procedure are amended in relation to the commercial courts. Now, it is very difficult to say whether they are rules, sections, sub-rules, very difficult. It is scheduled. Then in schedule, we have 1, 2, 3, 4 like this. Then you may, I don't know how to say it, in schedule, for my reference, I will say as item number 4, it is amendment of first schedule to the Code of Civil Procedure. First schedule contains the order portion. There you will get 4 capital D, Roman 2. This is how you have to read 4D2. After Rule 3 of the Civil Rules of Practice, the following rule shall be inserted. That is Rule 3A. We can roughly say Rule 3A is inserted in Order 8. Denial by the defendant in suits before the Commercial Division of the High Court or the Commercial Court. Denial shall be in the manner provided in sub-rules 2, 3, 4, and 5 of this rule, that is CPC. The defendant in his written statement shall state which of the allegations in the particular paras of the particulars of the plaint he denies, which allegations he is unable to admit or deny, but which he requires the plaintiff to prove, and which allegations he admits. So apart from the provisions relating to denials contained in rules 3 to 5 of the Civil Procedure Code, those of you who are practicing in the commercial courts need to know Rule 3A, which speaks of some more details regarding these admissions and denials. I repeat, the defendant in his written statement shall state which of the allegations in the particulars of the plaint he denies, which allegations he is unable to admit or deny, but which he requires the plaintiff to prove, and which allegations he admits. Then, where the defendant denies an allegation of fact in a plaint, he must state his reasons for doing so. He must also say why he denies. And if he intends to put forward a different version of events from that given by the plaintiff, he must state his own version. Then, if the defendant disputes the jurisdiction of the court, he must state the reasons for doing so, and if he is able, give his own statement as to which court ought to have jurisdiction. Here, it is not in the case of this commercial courts. I am of the view that in view of Section 9 CPC, there being a presumption that all suits of a civil nature can be tried by a civil court, the jurisdiction of the court is presumed. Jurisdiction of the civil court is presumed. Authorities say that no authority is required to say that the civil court has got jurisdiction. Many times the defendants vaguely say that this court has no jurisdiction. Suit is not maintainable. Why the suit is not maintainable? Why this court has no jurisdiction? If this court has no jurisdiction, which other court? Or which law bars this suit from being filed in this court? I have been telling the judicial officers in the Judicial Academy in the state, if there is such a vague plea in the written statement that this court has no jurisdiction, suit is not maintainable, don't frame any issue at all, because the presumption is that the civil court has got jurisdiction. In fact, a very learned judge of the Karnataka High Court, when he was addressing the judicial officers in the academy, used to tell, judicial officers should jealously and zealously guard the jurisdiction of the civil court. If you do not guard your own jurisdiction, who else will guard it? Therefore, there must be a very clear plea in the written statement why this court doesn't have jurisdiction. Is it pecuniary? Is it territorial? Or is it on subject matter of the suit? Or any other law bars it? If the defendant disputes the jurisdiction of the court, he must state the reasons for doing so. And if he is able to give his own statement as to which court ought to have jurisdiction. If the defendant disputes the plaintiff's valuation of the suit, he must state his reasons for doing so. And if he is able to give his own statement of the value of his suit, then there is also an amendment to Order 11, Rule 4, dealing with the intradictory. Order 11, Rule 4. Admissions and denial of documents. That is, as far as the commercial courts are concerned. Each party shall submit a statement of admissions or denials of all documents disclosed, and of which inspection has been completed within 15 days of the completion of inspection or any later date as fixed by the court. The statement of admissions and denials shall set out explicitly whether such party was admitting or denying correctness of contents of a document, existence of a document, execution of a document. These are expressions which you find in the Evidence Act also. Issuance or receipt of a document, custody of a document. Explanation. A statement of admission or denial of the existence of a document made in accordance with Sub-Rule 2B shall include the admission or denial of the contents of a document. Each party shall set out reasons for denying a document under any of the above grounds, and bare and unsupported denials shall not be deemed to be denials of a document, and proof of such documents may then be dispensed with at the discretion of the court. Any party may, however, submit bare denials for third-party documents. Other details are given. At one stage during the course of this presentation, I said that the proviso to Section 58 of the Evidence Act is similar to the proviso to Order 8, Rule 5. And I said that I would take it up at the end. Now is the time for me to take it up. Please go through Order 8, Rule 5, Sub-Rule 2 again. Order 8, Rule 5, Sub-Rule 1, proviso. Provided that the court may in its discretion require any fact so admitted to be proved otherwise than by such admission. Go to Section 58 of the Evidence Act. We have a similar proviso there. 58 main part, no fact need to be proved, which the parties agree, provided that the court may in its discretion require the facts admitted to be proved otherwise than by such admissions. So there is an indication from this Evidence Act of 1872 that even in the 19th century, there were collusive suits. It is not of a recent origin. I was told 3 days back by one judicial officer that there is a bar for sale of Gomala lands, change of Khata and other things. A suit is filed for declaration of title in respect of Gomala land. Defendant files a written statement conceding for a decree. Someone else told me that after a decree for specific performance, and when the draft, when the sale deed is taken to the office of the sub-registrar to get it registered, the registrar, based on some rule or some government circular, refuses registration on the ground that some sketch is not produced. To overcome all that, some suits are filed consenting for a decree. This is a case where the courts will have to be on the dark. My request to the legal fraternity is, please do not file such collusive suits. Don't try to overtake the law. You may have success in the initial days, but in the long run, it will not pay. Just give consent for a decree which cannot be passed. Some government property, claiming adverse possession and all that. You'll have to be extremely careful, because a judicial officer who is aware of the provisions of Order 8, Rule 5, more particularly Section 58 of the Evidence Act, would call upon the plaintiff to prove his case despite such admission by the defendant. Don't find fault with such judicial officers who do it. Law empowers him to do it. He has a duty to do it also. I go to that extent. I will give one example. Now, one X was in government service. He shows the name of Y as his nominee. He says Y is his wife, she is his nominee. X, another woman files a suit for declaration that she is the legally wedded wife of that X, and defendants are her children. She does not implead that Y. The name of Y is found in the service records of that X, that man. She shows him as his wife. Another woman claiming to be the legally wedded wife of that man files a suit for declaration that she is the legally wedded wife of him, and defendants are her children. The defendants give a show of contest. First day they would be watching whether the summons is served. They will just watch. If the summons is not served, the court issues fresh summons. Then on some other day, if the summons is served and the court is about to place the ex parte, some counsel suddenly stands up, or the parties say, well, we would like to engage a counsel. All that to give an indication to the court that there is going to be a serious contest in the matter. 15 days later, a counsel appears, files a memo saying that he undertakes to file wakalat. 15 days thereafter, he files wakalat, the usual time for written statement and all that. One fine day, he files, both of them file a joint memo to refer the matter to Lok Adalat for settlement, or he files a written statement conceding every averment made in the plaint. Who are the defendants in that suit? The children of the plaintiff. They would be happy if their mother is declared as the legally wedded wife of their father, if they are declared as the legitimate children of that person. Court should be on guard. Call for the service records. What made this woman to file a suit? Government denied her. You get a declaration. That wife whose name finds a place in the service records should be made a party to the suit. Order 1, Rule 10 empowers the court to implead such persons suo motu. My only request to the lawyers is, if there is such a judicial officer who is true to his job, don't discourage him. Don't find fault with him. He is after all doing his duty, not exercising his power. This is all what I wanted to tell you with regard to admissions and denials. Thank you for your patient hearing. If there are any questions, and if I am capable of answering them right now, I will do it, or otherwise on some other occasion. Thank you, Mr. Vikas Chatra.
No, sir, it's always a.
I think
Whenever you speak,
this time I have stuck to the time. This time I have stuck to the time.
But the way you take the session forward, it's so mesmerizing that I sense not only me, the other people also get awestruck as to how you interplay all these sections and other things with such an ease. This is in a statement or a counter defendant, denial specifically denied the plaintiff's case, but at one place instead of the documents filed by the plaintiff are created, he pleaded the documents filed by the defendant. So you can read that question. That's at 722.
In a statement or counter, defendant denial specifically denied the plaintiff's case, but at one place instead of the documents filed by the plaintiff are created, he pleaded the documents. It is not an admission. He can seek an amendment to the written statement. By mistake, he has said that the documents filed by the defendant are created. It is an inadvertent thing which has come in. That cannot be taken as an admission. The best thing for him is to make an application under 617 CPC to get over that. Very liberally, such applications are allowed. Then another question, explanation of the use of section 145 in civil matters, which is normally used for police diaries since insertion in 1974. Please suggest some reference. I am not able to give you any citation as such. That example which I gave of a partition suit filed by the plaintiff, wherein in some document he says that there is already a partition. Therefore, that can be taken as. Then there may be situations where the title, there all right, there may be another case. Suit is for declaration of title in respect of a property. In some other sale deed, it might have been mentioned that to the east of the property, there is the property of the defendant, which is none other than the suit property. This is also an admission. These are things which can be made use of while confronting the plaintiff or the defendant under 145 of the Evidence Act. As the advocate has rightly put it, this statement, this 145 CRP Evidence Act is made use of only during criminal trial when the witness is cross-examined with reference to the statements under 161. There is absolutely no bar for doing it. As I jocularly tell, these book publishers give this Evidence Act along with CPC and CRPC, and many think that Evidence Act is only for criminal trial. And similarly, as far as Limitation Act is concerned, it is with CPC, and in the law college also in some universities, Limitation Act is a part of that CPC paper. And therefore, lawyers think that Limitation Act is not applicable to criminal cases, and Evidence Act is, I am jocularly telling it, this is the problem. And most of the illustrations in the Evidence Act are also in relation to criminal matters. That is the reason. This is how 145 can be made use of.
Yeah. And on the YouTube chat, it's all praises that you should keep on taking more sessions. We are so impressed by your insights. One last question is, can we mark depositions in one case in another case when the witness is dead?
Yes, section 33 of the Evidence Act provides for it. We can do it.
Yes, sir. So thank you, sir. It was a really enriching session, and we hope that people, those who have missed it, can always watch it subsequently. And tomorrow, though we talk of the session of Beyond Law CLC, we will be taking by Mr. Amarjit Chopra, a former president of the Chartered Accountants Association, careers in chartered accountancy. So do stay connected with us at 4 p.m. And we would request sir to take sessions more often. And it's always a pleasure for everyone to have pearls of wisdom from you. Thank you. Stay safe. Stay blessed.